Okay.
So, Mr. Smithee to lay out, Chair recognizes Mr. Smithee to lay out House Bill 3017.
Thank you, Mr. Chairman. I know most of you know what discretionary clauses are in insurance contracts. Basically, they're provisions that are placed in the contract that say that if there's a disagreement as to interpretation of the insurance contract or construction of the contract, it will be construed in accordance with the insurer's construction. And typically a court is required when construing that contract to presume that the insurer's construction or interpretation is the correct interpretation or construction. Because of that, insurers are almost able to make the contract say whatever they wish it to say. And because of that, many times claims that could arguably or even ostensibly covered under the policy, a company, the insurer, is able to avoid coverage simply by adopting a contrary construction or interpretation. Any company that would represent that this is a good idea, you have to wonder how they would feel if the shoe were on the other foot, if the contract said that the insured would have discretion to interpret the contract any way the insured wanted to. Obviously, you're not going to get an unbiased or fair construction from either party in most situations, and so it is. I think it's incumbent on fairness and fair play to have a neutral third party at least determining what the coverage means. Generally, a matter of coverage is a question of law to be determined from the four corners of the insurance document, and but usually that is a legal question determined ultimately by a court, but certainly not by one of the parties in their own discretion. I think that a lot of credit has to be given to our Office of Independent Insurance, Office of Public Insurance Counsel, Deborah Beck, who first really brought this issue to the forefront as she saw it being used more and more in policies being written here in Texas. She alerted the legislature as well as the department that there was an issue here. She brought it up and pushed the issue. I think we also need to give acknowledgement to the department, particularly the commissioner who reviewed this issue and took remedial action to adopt rules to prohibit many of these types of clauses. Now, there's some question, why do you need a statute if we already have a rule? Well, I think one reason is passing it into law would make it more bulletproof as far as challenge would be concerned, and also I think it would be good policy to have it in the insurance code to prohibit this type of clause as being unfair to the policyholder or the consumer. So having said that, Mr. Chairman, if there are any questions, I'll be glad to turn it over to any witnesses that we might have.
Questions? All right. David Rankin and Deborah Rankin for the bill.
And we need both of y'all to state your names, if you would.
Good afternoon. My name is David Rankin.
I'm Deborah Rankin. Mr. Chairman and members, thank you for hearing us. In 2006, my husband was diagnosed with MS, and he worked for a Fortune 400 company here in Austin, which provided policies that they could pay for long-term disability. After his diagnosis, we were forced to move from a two-story house into a one-story house to accommodate the fact that my husband cannot do stairs, and he could no longer work. He went through his short-term disability and then was determined to be retired disabled by his company because of his doctor's diagnosis and his physical and cognitive disabilities. We went on to long-term disability to be denied. The doctor that denied him had never laid eyes on him. It was actually in Rhode Island. We had to hire an attorney. It got quite expensive, and it actually wrecked us financially because I became sole support, and he was getting Social Security disability at that time, and that's all we had. We went through all of our savings with an attorney. we finally came out on the winning end of it, but we're very appreciative for the Texas Department of Insurance rulemaking, and we would ask that this bill would help make the rest of Texans, insurance companies, where they can't make those kind of decisions unfairly anymore, that it levels the playing field, because it's really not a level field. And this should really never happen to another family in Texas. Thank you for your time.
Yes, ma'am. Thank you. Any questions? Thank you, Mr. Ms. Rankin. Lene Nassman? Yep. She's got I'm going to change your marker to, you did testify, since you did. Will you come state your name?
And say whether she's for it.
And if you're for or against.
My name is Linnea Nassman. I'm with the National MS Society Lone Star, and I'm in support of this bill.
Okay, so I'm going to change, with your permission, change your marker to you did testify.
Okay, thank you, sir.
Good. All right, the following people are registered but do not wish to testify. Patricia Colozzi from the TMA is for the bill, does not wish to testify. Deborah Beck, OPIC, is neutral on the bill, is a resource only. Does anybody want to talk to Ms. Beck about the bill? Stacy Pogue, Center for Public Policy Priorities, is for the bill, does not wish to testify. Trey Bernot from AARP is for the bill, does not wish to testify. Doug Danzizer from TDI is resource only, neutral on the bill. Anybody have any questions for Mr. Danzizer? No. Gail Switzer from Mental Health America of Texas is for the bill, does not wish to testify. Ware Wendell from Texas Watch is for the bill, does not wish to testify. Michelle Apodaca from Texas Hospital Association is for the bill, does not wish to testify. Anybody else here that wish to testify or register your position for, on, or against House Bill 3017? Chair has done. Recognize Mr. Smithee to close.
Mr. Chairman, I think this is a good bill, and it's something we should do. One of the concerns that has been voiced is that if for some reason the bill were to pass committee and not pass the House, or not pass get through the Senate, or else if it were to be vetoed, that it might undo or weaken the regular rule that's in effect. And so I want to try to work this week to try to get the committee some assurance that we obviously can't guarantee anything, but some reasonable assurance that this can get all the way through the legislative process before we actually move it out of committee. But hopefully we can do something this week if that's okay with the committee.
Yes, it's okay with the committee. All right. Then the chair's attempt to leave House Bill 3017 pending for the committee, subject to call the chair.
Okay, thank you.